said I'll return her mail. I'll see her in a few months.
Morning. We'll call the meeting to order on April 22nd, 2022 at 9:01 a.m. First item is roll call. Dr. Bruce Bedoli.
Here.
Dr. Bazzini.
Here.
Dr. Coble.
Here.
Mr. Daniel.
Here.
Dr. Downing. Dr. Drake.
Here.
Dr. Kerrigan.
Here.
Mr. Parsons.
Here.
All right, everybody's here. Item number 2 is the review and adopt the minutes from the previous meeting of January 21st. Does anybody have a motion to approve the minutes?
Motion.
Second?
Second.
All those in favor say aye.
Aye.
Opposed? All right, item number 3 is the administrative update.
Can you all hear me okay?
Yes.
Okay. So we have a budget status report, which incorporates travel that we weren't doing during pandemic. So it's been updated to reflect those expenditures. And I didn't because my dad had quadruple bypass, but our colleagues here, Robert and Lee, both attended the Academy meeting. And I think it went well. Lee has been selected to chair the program for jurisprudence for this next meeting, which is happening, I think, in Orlando. Orlando. So that's a big job. And we may be reaching out to everybody goes to jurisprudence. It's the place to be at the Academy meeting. So we may be reaching out for ideas and help for themes and panels and things like that as we move forward. So that's exciting. And we, so the final stages are underway in the programming of our online database system. Dr. Kerrigan had an opportunity to see it, at least in its basic form, how it's going to look specifically for OSAC compliance documents. And I think, Dr. Kerrigan, I don't want to speak for you, but I think you were happy with the way it's coming along. So
Fantastic. Yeah, it's incredible.
So, and we've actually had outreach already from other folks who are involved in the implementation process, just asking questions about how we did it and what categories are there and everything. So that's exciting. So that's all I had. Lee, did you have anything else?
I mean, I would just say the level of attention that we're getting from these programmers is awesome, and they're doing a really wonderful job. And I hope that by the end of the summer, we got an updated timeline. So by the end of the summer, we should have everything live. And then we have some reporting functions that are going to be really useful for our staff. And those will come later in the year, I think, after we go live with the site. So I'm excited about it. And I know that Rodney and some of our staff that do a lot of the entry work are excited about the program as well.
I think unfortunately you might have heard about bail reform taking up a lot of time and energy recently. So they got pulled away to do some programming for that effort. But now they're back on task. So we're in good shape.
Anything else? Congratulations, Lee, I think. You have a different opinion by the end of it, but all right, item number 4 is the discussion of the pending complaints and laboratory self-disclosures. Mr. Daniel.
Yes, sir. Dr. Bernard, we had 9 self-disclosures and 5 complaints for consideration at this meeting. We do have one holdover self-disclosure out of Brazoria County from our January meeting. And our first item is 2171 Brazoria County Crime Lab Toxicology Unit. We, as I said, looked at this previously in January. Their lab had detected a systemic issue of blood alcohol analysis where the variation among values obtained from blood samples in the same case exceeded their 10% maximum for reanalysis. And said the laboratory practice would simply disregard that data, and as they needed to stay within the 10% requirement and report blood alcohol results to the submitting agencies without really reanalyzing it. So while they're reviewing the blood alcohol issues, management found a number of other issues. They found some concerns about methods for analysis of drugs in blood. They found weaknesses in some of their quality assurance documentation. They found the laboratory director had suspended blood alcohol and blood analysis, and they had tried to outsource that to DPS, which is almost overwhelming. They right now have 300 blood alcohol cases and 150 blood drug cases, and DPS use is only taking about 20 at a time. So it's going to take a time to work through that backlog. Staff had reviewed this carefully and had come to a recommendation that we accept this self-disclosure for investigation to assess the scope and impact of the current issues in their blood alcohol and drug blood analysis, including the impact of technical issues the lab identified in the disclosure by ANAB and other issues reviewed. So if there are any questions, comments, or concerns, I'm prepared to make that in the form of a motion.
Is there any discussion? All right. So motion's been made. Is there a second?
Second.
And this will be for an investigative panel. All those in favor say aye.
Aye.
Opposed? Okay, the motion carries. I think probably some good panel members would be Dr. Kerrigan, Dr. Drake, and Mr. Parsons.
That's a motion. I'll second that.
All right.
Which brings us to our second matter. It's item 22.01. It comes to the Houston Forensic Science Center, the Forensic Biology and DNA Unit. And in January, they had reported concerns with regard to analysts' explanation during testimony of statistics related to DNA. The laboratory had secured 3 transcripts from the same analyst and identified one additional concern involving a lack of statistical information that the analyst conveyed. The lab also found one additional transcript and is actively seeking 2 more from the court reporters in the respective court trials. The lab notified the Harris County DA's office regarding the issue. The analyst is actually a contract employee, formerly a full-time analyst, and now performs reviews on outsourced cases as the schedule permits. The analyst is going to receive some remedial testimony concerning training, including mock trial, and made to understand the key statistical concepts and how to communicate them in the courtroom. I don't think it was so much along the perjury, just a misunderstanding of how to communicate things. So frankly, in light of the action, root cause analysis, the transcript review, and other correct actions taken by the laboratory, staff had made a recommendation, no further action. And I'm prepared to make that in the form of motion unless there are any questions, comments, or concerns.
Excuse me, Mr. Daniel, I did confirm with the laboratory that they will be doing extensive training on statistics as well as on testimony. Because sometimes it's hard to articulate concepts if you don't fully understand them. So they just want to make sure they've covered all the bases there.
Good.
So, was this pre-star mix or was this after? Was this likelihood ratio involved?
No, it was pretty.
Okay. Thanks.
So I will make a motion, take no further action.
Is there a second?
Second.
All those in favor say aye.
Aye.
Motion carries.
The next item is 22.02 from the University of Texas Health Science Center, Center for Human Identification. It may be appropriate that Dr. Coble and Bedoli possibly recuse themselves on this matter.
Yes.
And this is the refrigerator issue. Back in December, the walk-in freezer entered alarm state on a Friday evening. On a Monday morning, quality manager detected that, immediately notified the repair folks on campus. Frankly, the lab did everything they were supposed to do. They repaired it immediately. They removed every item of evidence from the freezer one at a time. They photographed, inspected everything for visible damage. Any items that appeared to have any stains or tears were repackaged in another clean package. And they did not discard the packaging. They even included gloves and countertop underpads when each handling, and probably more often they actually needed to. They notified all the affected agencies. They replaced the monitoring system with a new, more reliable system. They determined it affected about 222 cases, and due to the nature of the event, the lab is unable to predict the ultimate impact on the freezer failure on samples. So they've notified all stakeholders. They're going to include a statement and effective case reports of untested items noting the occurrence of the event. Staff had reviewed this carefully and provided us complete information on it and had made a recommendation to take no further action. And in light of that, I'm prepared to make a motion if there are not any comments, questions, or concerns at this time.
I have a question for the laboratory. So how did you decide upon the statement that's going in the reports? Is that something that has always existed, or, you know, when you might have like a evidence packaging type concern, or like when an item comes in and it might look like it got damaged somehow, or is this something that's like specific to this freezer breakdown?
It's very specific to this
Mhm.
instance. Basically, you're stating what the notification went out to all agencies. You're restating that in the report, and now saying that it was not tested beforehand. You're saying these items have now been tested.
Okay, and the self-disclosure indicated that the laboratory will be unable to make any definitive statements about potential impact in terms of degradation or carryover. And is that just a general principle, essentially, that once the freezer goes down, it's hard to know because you don't have the before data, so one doesn't know definitively ever, right? Is that fair?
That is fair.
Okay.
I will say that many of the untested forensic cases, they were screwed previously by tested, yes. So there is a before snapshot of the male getting screwed. So we know in general what types of results we would expect from those samples. So there's some level of checkwork. And then we are still discussing the plan for evaluating potential concentration. Because we do have a grid, we know every item is located, and so we can cross-check between the samples.
And you would do that using like Gene Mapper, or how would you check?
We're still evaluating
Mhm.
that, but it may literally involve manual comparisons.
Oh, wow, okay.
Yeah.
All right, okay, thank you.
The motion has been made for no further action. Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Which brings us to our fourth item, which comes out of NMS Labs, item 22.06, seized drug section. Back in February, the lab had found an incident where the seized drug section had underestimated its uncertainty of measurement for a value range in 76 cases that resulted in 65 corrected methamphetamine quantitation reports. The lab found analysts had failed to recalculate the uncertainty of measurement value for conversion of the result from freebase to the hydrochloride salt form of meth. The laboratory's procedure did not have clear instructions on how that conversion was to be done. The lab set about to have its analysts recalculate the original uncertainty of measurement to account for conversion from the salt form. The management reviewed the data, confirmed the calculations were then done properly. The lab also issued amended reports in 65 separate cases. And many of y'all may know in connection with federal matters, it matters significantly if there's ice or that form of methamphetamine. So after discovering the error, the laboratory briefed staff and updated its instructions for accurately analyzing and reviewing quantitative cases. They further updated all their SOPs to include instructions on how that quantitative result and uncertainty measurement is done appropriately. Staff had briefed this matter thoroughly. They had brought forth initial recommendation of no further action, given the root cause analysis, the case review, and other corrective action taken by the lab. And I'm prepared to make that in the form of a motion unless there are any questions or comments or concerns.
Any comments? All right, motion's been made. Is there a second?
Second.
All those in favor, say aye.
Aye.
Opposed? Motion carries.
And our fifth item is 22.07. It's from DPS here in Austin, their forensic biology and DNA unit. Back in February, they discovered a missing envelope of hair evidence. The incident actually kind of began back in 2020 and pertained to evidence item back in 1999 and 2000. Gee, that seems like a long time ago. They made extraordinary efforts to try to locate the item that are unsuccessful. They determined it may be a barcode label loosening issue. After a while in the freezer section, it tended to come loose. They notified all the stakeholders by email, and the investigation of the missing hair concluded, and the lab did not locate any of their missing items. They've since made an adjustment on the freezer safe tape to cover the barcode issue. So it looks like they've taken steps to ensure this does not happen again. Again, staff had done a very good job briefing this. They had brought forth a recommendation of no further action in light of the root cause analysis, the case review, and the corrective actions taken by the laboratory. And I'm prepared to make that form of motion unless there's any questions, comments, or concerns.
All right, is there a second?
Second.
All those in favor, say aye.
Aye.
Motion carries.
Brings us to our sixth item is 22.11. It involves a Fort Worth PD crime lab, firearms, tool marks, and NIBIN issues. A former employee had brought forth a report that the lab, quote, never documented any of their actions as related to NIBIN test fires. In response to allegations, staff had reached out and sought to obtain information from the lab, including responses to questions regarding the documentation of NIBIN test fires at the lab. Staff reviewed all the submitted materials, determined that the crime lab does retain a record of NIBIN test fires in a spreadsheet, but they generally did not create a case record for the weapon in the laboratory management system unless additional comparisons were requested. Staff notified the laboratory of that issue. That's also in your meeting materials. They determined there's some non-functional firearms for NIBIN that carry a risk of information being lost or manipulated. It sounds like a lot of times they were taking weapons that were not usable, putting them back together where they were usable, and not documenting that the way they probably should have. ANAB directed Fort Worth PD to review its NIBIN processes and address any non-conforming work, including corrective action in accordance with their management process system. And it looks as if they've corrected this. So staff had made a preliminary recommendation to the commission that we take no further action with a requirement that the lab provide the results of the NIBIN process review requested by ANAB. That's still forthcoming. Am I correct, Lynn?
Yes.
Okay. So unless there are any questions or comments, concerns, I'm prepared to make that in form of motion.
Any comments? All right, a motion's been made. Is there a second?
Second.
All those in favor, say aye.
Aye.
Opposed? Motion carries.
This brings us to our seventh matter, which comes from the Barrett County Criminal Investigation Laboratory Seized Drugs Unit. Back in March, the lab reported a failure to retest toluene used for thin layer gas chromatograph tanks in the proper retest date. The lab did not have an established procedure for doing that. It turns out that toluene degrades to benzaldehyde and benzoic acid when reacting with oxygen and water. The lab set about to order a new toluene to replace the current bottle. The lab also created a log for retesting the current toluene until the new supply was received. They created the same process for hydrochloric acid and sulfuric acid to verify monthly pH levels. They also instructed analysts to label the outer chemical container with initials as far as date open, storage condition, lab lot, expiration dates, and every piece of information necessary. Analysts were also instructed to write this information in these secondary containers as well. And they instructed staff to notify their supervisor assigned to the specific cases concerning chemicals if they find a chemical approaching an expiration date. And they now have an analyst to check these expiration dates on all chemicals. I'm going to jump off the script here in a second and just say something. This is kind of the reason this commission exists. This lab made a mistake. They came forward and fell on the sword. They did every conceivable thing they could to correct it, which is kind of why we exist. And it's been done. So staff had made a recommendation of taking no further action in light of the root cause analysis and all the corrective actions taken by the lab. And unless there are any comments or questions or concerns, I'm prepared to make that in the form of a motion.
Any comments? Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Which brings us to our eighth matter, which comes from the Fort Worth PD Crime Lab. It's item 22.17. It concerns proficiency testing nonconformities, and it's a little more complicated than some of our other matters this morning. Back in March, the commission received a self-disclosure from Fort Worth PD Crime Lab, sharing with us some nonconformities cited by ANAB during their review of the monitoring records. What they showed was that proficiency test participants submitted their completed tests after the manufacturer published consensus results. ANAB had requested additional monitoring records from the lab. ANAB evaluated these records and indicated there are some systemic instances of nonconformity. They had sent a letter to the lab to conduct an investigation to determine the cause and extent of the nonconformity cited by ANAB, including an evaluation of the risk and extent or impact on casework. The lab set about to address this. The first thing they did was to create a committee. The committee reviewed proficiency test case records identified in the letter. The lab found about 15 proficiency test cases were submitted after the manufacturer's results were published. The laboratory explained its corrective action that while it was known that each test had a due date established, various factors prevented their complete compliance before those dates. The lab then gave each analyst approximately a month from the date of issue to complete their proficiency test. They also found 7 instances of non-consensus tests from 2015 to 2021, 6 of which involved the analyst reporting inconclusive instead of the manufacturer consensus of included or excluded, however it may have been named. The current investigation focused on the remaining 6 non-consensus results of quote inconclusive. The crime lab is not historically considered an inconclusive determination as opposed to the manufacturer's expected result of included or excluded, however named as an error. And during the investigation, the lab also found out that the firearms unit did not have a designated range of conclusions or specific criteria for reaching an inconclusive determination. The lab set about to do some extensive corrective action. They had a quality manager work with analysts to ensure results are submitted prior to the release of the results. They revised the proficiency testing policy to reflect that all purchase CTS results shall be considered external proficiencies and results will be submitted directly to CTS. They also revised a policy to specifically require a corrective action report for any conclusion that's reached that is not the manufacturer's intended result. Staff had come forward with a recommendation that we table this to address some of the concerns we have about the impact of historical non-compliance on our licensure of those individuals who submitted proficiency tests after publication of results. Staff can continue to work with ANAB on this matter also. If there are not any questions, comments, or concerns, I would make the motion to table in this matter to allow staff to do more work and maybe bring this back to us in July or next meeting.
Just to give a little bit of a sense, we have the issue with taking PT after the result had been published. So that's one issue. We have the fact that you had inconclusive results being provided by examiners where that was not aligned with the consensus. And what they were doing was just the quality manager would have a conversation with the analyst asking, well, why did you call it inconclusive when consensus is include or exclude essentially. And they would have a conversation and that would be the end of it because they had a provision in their SOP that basically said inconclusives can't be wrong. Well, that's not okay fundamentally. And what's been interesting to watch is the current acting lab director comes from the DNA unit. And so for her, a lot of this is foreign, that one would just sort of allow an inconclusive bucket to sit there as a place for collecting the analyst's lack of ability, I guess, to make an inclusion or an exclusion based on defined criteria. So in some senses, that inconclusive bucket issue is kind of prevalent in firearms, actually. There's been a lot of criticism out there about that particular issue, is the tendency to use the inconclusive finding or overuse it, I guess. And there are certainly circumstances where inconclusive is the appropriate call, but it also shouldn't be used as sort of a catch-all call to make. And when one chooses it and the consensus result is otherwise, there needs to be a quality incident and investigation of why. So people understand whether this person, the whole point of proficiency testing is to figure out whether they're able to do the work appropriately. So all that is to say that last night we got an updated SOP from Fort Worth that removes the provision around, this inconclusive bucket being there and available and not considered an error. And also, I think they've made a number of adjustments. I just haven't had a chance to really dive into it. So they're working on it. And ANAB is very intent on getting this addressed because they understand and appreciate that the fact that they didn't see it sooner themselves is actually an accrediting body nonconformity. So they're looking at it from a variety of angles. And then another issue has come up, which is if you look at the chart, the matrix that we put in your materials, it says comprehensive chart of proficiency testing cases identified by ANAB for review. Well, one individual who was in management is on this list a lot. And so what that raises a question about is whether or not people who don't do casework with any real frequency because they're in management should maintain a licensing credential or continue PT when they don't really ever do casework. So that's a conversation we're going to have with the licensing advisory committee at the next meeting as well. And I think the lab directors are thinking about that. In a larger laboratory, the sort of the dropping off point for licensure perhaps is a little more pronounced. In smaller labs, you do have people in management roles who may actually quite frequently do tech review as needed. So we can't have a one size fits all solution, but there needs to be some level of inquiry about when it's appropriate to hold that license. And then yesterday, Erin Reed, who's the chair of our LAC, brought up the fact that, ANAB won't tell you a specific number of how many cases is enough to maintain competency. But generally, he said, if it's under 5, it's too few for a discipline when they're evaluating disciplines. So there is some understanding and accreditation as well that if the lab's not performing a test method frequently enough, perhaps it shouldn't be on their scope. So we're going to have a similar conversation about licensure. So hopefully that helps. It's a fairly large issue that we need to really dig into and understand, because it has both the why would you be taking PT after the results are out question and the actual, is the analytical work sound, or are we throwing everything into inconclusive question, and how these things get resolved. from a quality standpoint and the licensing question. So it's quite a few things.
All right, motion was made.
Yes.
Is there a second?
Second.
All right, all those in favor say aye.
Aye.
Opposed? Okay, this will be tabled.
Which brings us to our last disclosure. Item number 9 is case number 22.18 from the Houston Forensic Science Center, the Forensic Biology DNA Unit. And I'll begin by telling you that the recommendation from staff is to investigate the disclosure to address possible professional negligence or professional misconduct. It comes from a trial back in May of 2017 where Joseph Clone was convicted of capital murder. The primary evidence linking him to that offense was an item consisting of a mask and also a blue towel wrapped around one of his hands. It had been located at or near the crime scene, laying outside the bathroom. In June of 19, there was a post-conviction writ done following the conviction, and post-conviction counsel began interviewing and deposing all of the experts. What they came to learn was that the item of evidence had been subjected to being included in a styrofoam cooler that had some moisture and liquid inside of it. Stephen Benson was actually analyst when he set about to testify. He made a statement that as far as the condition of the physical evidence, that nothing was, quote, awry about the physical evidence. What we really don't know is if that's something he just didn't know, or his answer was something to the effect that staff had received the evidence in the lab when it came in, and therefore he just assumed it was okay. Truth is, there was a note that said that the packs were at room temperature, not refrigerated. The FedEx envelope is damp and soggy. There's a foul smelling water liquid at the bottom of the container. And there was certainly some potential contamination. They had a post-conviction writ hearing referred back to the trial court, and the trial court had made some fairly damning findings. He found the analyst's answers to be somewhat evasive, misleading, even used the word false. He said there were some concerns about the post-conviction testimony lacking credibility, and he found it troubling that the analyst's overall demeanor was concerning and undercut his credibility. So the trial court found the admission of this evidence to be possible motive to obtain the defendant's conviction through the use of false testimony.
Mark, say that again. The trial court found what?
The trial court found that the admission of the evidence of a possible motive to obtain the defendant's conviction through the use of false testimony by the analyst.
Okay.
So it's a very serious matter, and staff had made what I consider appropriate recommendation that we investigate it carefully, determine if there's possible professional negligence or professional misconduct. I'm prepared to make that informed motion. If we do that, we'll probably need to form a committee.
Is there any further discussion?
Yeah, can you hear me?
Yes.
Yes.
Yeah, I just wanted to bring a point up is that in this case, the analyst testified from his report and never looked back at his case notes. And especially if you had a case that's 3 or 4 years earlier been processed, it's difficult to recall what may have happened in the case. And I think something about the practice of relying just on a report should be further consideration in this evaluation.
Okay.
Do we have an idea what the state's position was in this case? Was it, did the judge
They
grant a new
joined the
trial?
writ.
They joined in the writ? Okay, got it.
All right, so a motion has been made. Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Okay, motion carries. So the panel members, recommended panel members would be Dr. Bedoli, Dr. Downing, and I think we need a prosecutor representative. So Mr. Parsons.
Okay, so I'm on both of these right here. Am I right?
Yes.
Number 9 and number 1.
Yes, well, we won't leave your counterpart out.
Okay, as long as there's enough to go around at some point in time.
Oh, absolutely.
I just did there's 3, I think. And so I just counted them up.
Okay.
to divide it, but if you want to swap, it's.
We value
totally-
your,
That's what it
your
is.
input.
Get it now. That's what it is.
If you want to switch with Mr. Daniel, Mr. Parsons, you're welcome to.
We
It's
may-
either way.
Speak at the break.
I'll do that.
We may switch at the break.
What do you want to do?
I will actually, if you want to do number 1, I'll do number 9.
Well, that would require me to look back and see what number 1 is.
Pretoria County,
Missouri.
Missouri, the blood, yeah, that would
That
probably
was
be good.
Cool.
Fine. Yeah, it's good. I hate for you to have to work.
Yeah, well, all right. So panel's been made.
So do we need that as a new motion to put me on the committee for number 1?
Yeah, we need to switch
Since
it.
we made a switch.
There wasn't a motion to start out with, but do we need a motion to make the change?
I-
mean, the panel formation was a motion, but the members chosen
Was not.
was not.
Okay, let's just make sure we have it. I think we should vote on both. So on Brazoria County, the blood alcohol and the blood drug.
I'll make a motion to
Investigation.
substitute myself in on the investigative panel for Mr. Parsons.
Okay.
You say,
And
Is-
then in addition, we have Dr. Kerrigan and Dr. Drake. That's correct? Okay. And then on 10, pardon me, not 10, 9, we will have Mr. Parsons, Dr. Downing, Dr. Bedoli.
Correct.
and I'll make all that in the form of a motion.
Do we accept the panel members as discussed? Is there a second? All those in favor say aye.
All right.
Opposed? Okay.
Which would conclude our non-disclosure and bring us to our complaints. Our first complaint of the day is item number 10 is case number 22.03 from John Bonos against the Department of Public Safety Garland Forensic Biology Unit. He alleges the lab had created a fake dried blood stains and sent them to the FBI for DNA analysis way back in 1989. Gosh, it seems like a long time ago. The lab had shown a receipt of the vaginal swabs and panty cuttings along with dried blood stains, standards on the victims and the defendant both. DPS case records reviewed by staff indicate during that time the lab would create and freeze a blood stain on a card in order to create a reference sample instead of a tube. In this case, the DPS returned the blood cards to the submitting agency after testing, which then sent the blood cards to FBI for DNA analysis. And staff had made a preliminary recommendation of dismissal of this complaint because the allegations of planting blood are outside our jurisdiction, and the utilization of cards for blood reference were very common during that time. So I will make that in the form of a motion unless there's any questions, comments, or concerns.
All right. Hearing none, is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? The motion carries.
The next item is our 11th matter of the day. It's case number 22.04. Earl Bryant had made a complaint against Kimberly Lydell, a sexual assault nurse examiner. It pertained to testimony listed during trial where the sexual assault nurse examiner had, quote, changed her forensic examination report by improperly including an allegation attributable to prior abuse committed by a natural biological father. And what happened was you had the child testify that my stepdaddy had sexually assaulted me while I was in Paris, Texas. And there was a question about how often it occurred, and that we did it a lot. And she told us yes in response to that question. So there was a little ambiguity in connection with the testimony about whether they were referring to a father or a stepfather in that regard. Commission had contacted the sexual assault nurse examiner who testified in the case. She did not recall specifics, but agreed that her testimony could have led to some confusion. She was certainly willing to provide some clarification. Staff had made a recommendation the complaint be dismissed because the allegations really involve patient history taken from the sexual assault nurse examiner and not the sexual assault nurse examination of physical evidence or the sexual assault examination itself. It was just the patient history. And certainly the record might be ambiguous regarding the child's statement and the potential confusion. That's something that the courts can certainly resolve. So unless there are some questions or comments, I will make that in the form of a motion to dismiss.
Is there a second?
Second.
All those in favor say aye.
Aye.
I would like to make a comment, though. It's still really concerning that the child statement wasn't disambiguated at the time of the trial. So I don't know if there's anything that could be done to address that, but the redaction of the information about father versus stepfather should have been done more carefully by whomever provided that redacted statement. So is there anything that we can recommend or?
I reached out to IP of Texas to take a look at it. That's about the best that they can look at the totality of the record and see if it's something they'd want to take up. It was mentioned, the fact that the testimony was confusing was mentioned in a footnote in one of the appellate opinions, I believe. So it was raised and the court considered it. So it's not like they didn't know that. I don't think there's anything that we.
Right. When I read that report, it didn't seem clear to me that the defense understood what the issue was.
They may not have that. That could be. But I think in post-conviction, the best that we're able to do, especially considering it wasn't an expert examination or test on physical evidence, really, that's at the heart of the confusion, would be to, we have lots of great resources in Texas, although fewer than perhaps we need, but, we just try to put things that we can't necessarily do anything about in front of folks who may choose to take it up. I mean, that's what we've done since we started. We put all the innocence clinics in our correspondence with them. So if they want to reach out, I just, the former SANE, she's an NP now, if I'm remembering right. She said if she were contacted, she would, submit some form of statement indicating that, there was a lack of clarity and that she recognizes that. So her willingness to do that is great. There's just not really a way to launch that into a filing or something without an attorney taking action. I think, is that fair to say? You all would know better than me, Mark and Jarvis, but.
Well, it's an evidentiary issue. She does this sexual assault nurse examination. She hears a statement from the complaining party. Frankly, she statement. That's the bottom line. That's what she could have been more specific about who said what and defining the individual that the child is referencing.
Right. Or I would like the forensic nurse to review her unredacted copy. She may have been handed the redacted copy by prosecution and then not remembered what the full statement was. So if I could at least try to address it from the forensic nurse training perspective, I would encourage them to review their complete documentation before they agree to testify on a redacted version. So
It would not have been a problem if she'd done that.
she may or may not have remembered whether it applied to the stepfather or the father, but she could have at least removed that ambiguous statement from the redacted copy.
So that could be part of a OSAC type guideline or standard, is when one is asked to work with redacted documents that involve statements of victims or survivors of sexual assault, then that could be added to the list perhaps.
Well, it seems like we're also dealing with the same issue on the number 9, where you're not looking at your bench notes before testifying. It's kind of the same process that's kind of going over and over again. Well, that we've seen twice today.
Yeah, I mean, the other one was pretty,
If if it's true, is Greek.
Mhm.
Okay, we need to finish the vote. Are there any opposition, any opposing? Okay, the motion carries.
Which brings us to our 12th item, it's case 22.09. It's a complaint brought by Tommy King against Southwest Institute of Forensic Sciences. I think Dr. Bernard may recuse himself.
I will.
Dr. Drake to preside over. King had made a claim of actual innocence, but more importantly, claiming false DNA testimony by Swift's analyst regarding some stains on his left forearm, his shirt, and also his pants, and also that there had been DNA evidence had been transferred to or painted on a knife after receipt by a second Swift's analyst. It alleged that DNA and blood evidence was found on his left arm. The allegation regarding that testimony really related to the forearm really wasn't supported by the record at that time. He also alleged that analysts gave false testimony about a match of the victim's DNA to his pants. And that testimony was offered at trial and was confirmed in the lab data reports. He also said that there was, the analyst testified at trial that there's a 1 in 33 probability of a match to the victim's DNA on his shirt. And Mr. King claimed that that testimony was proven false by the lack of an XX being on the allele chart in the report. The testimony of the analyst was actually consistent with the reported result. And then finally, he alleged that this knife had evidence painted on it or fabricated the blood and DNA evidence. There had been some testimony that he had been seen, the detective assigned to the case, that there appeared to be blood on the knife when it was retrieved, and claimed he believed the knife had not been opened until delivered to the crime lab. It appears that none of his claims were actually sustained, and staff had made a recommendation to dismiss the complaint because the assertions regarding the false testimony are not supported by the record, and generalized allegations that blood evidence was planted on were not supported by the record. We did receive an extensive response from Swift's late yesterday afternoon. It essentially confirmed that the two analysts, the samples didn't cross paths, as he alleged, further disproving or further refuting his claim of the false evidence. So I'm prepared to make that in the form of a motion to dismiss the complaint unless there are any other questions, comments, or concerns.
Do we have a second?
Second.
All in favor, say aye.
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 All opposed? Okay, the ayes carry, motion carries.
Which will bring us to our third matter. It's a complaint against Orchid Cellmark by Charles Martin. It's item 22.13. He had requested retesting of some blood evidence to establish paternity in a criminal case against him for sexual assault of his own daughter. It's a sexual assault that had resulted in the birth of a child. The results of the testing determined the defendant could not be excluded as a biological father of the child. Frankly, staff had reviewed the matter and it was fairly simple and straightforward. We don't have authority to order DNA testing. That's outside the scope of our jurisdiction. So the recommendation was to dismiss the complaint. And I'm prepared to make that in the form of a motion unless there's any questions or comments or concerns.
Do you have a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Now, our last matter of the day is item 14. It's 22.16. It's a complaint by Joseph Webster against Ron Smith and Associates concerning latent prints. I'll go ahead and tell you that staff had made a recommendation, which I concur with, concerning accepting the complaint for investigation. It all concerns fingerprint analysis and comparison, and also testimony concerning that. There had been a possible identification of a latent print as belonging to Webster that he complained was not reproducible. He said it conflicted with the findings of many pre-trial and post-trial examinations, finding there was no identification or that it was inconclusive. The complaint also alleges the examiner expressed her findings using language that really was not accepted within the discipline of fingerprint examination or comparison. And in 2016, he had been convicted from a 2001 cold case. The state's evidence and theory rest on really three pieces of circumstantial evidence. One was a palm print, which was known to be his left palm print. 2010, the investigators from Houston PD compared the crime scene with over 50 individuals and did not identify anybody. In 2011, a private lab looked at the matter and did not identify anybody. In 2012, they went back to their same private lab, which is Ron Smith and Associates, and they requested re-examination of bone prints for two persons of interest. And during the re-examination, the analysts requested police obtain an additional higher quality set of prints, and utilizing that known set of prints, they made a identification of Mr. Webster. At the time of the testimony, the examiner gave a conclusive finding that they belonged to Mr. Webster. The complaint alleges the testimony used language that had not been recognized as exceeding the limits of science, and that the examiner testified a number of examinations she performed in her career to bolster some confidence in the accuracy of her work. Staff has been very thorough in reviewing this matter. They had made a recommendation to accept the complaint for investigation for a couple of purposes. One is to review the observations regarding the integrity and reliability of the forensic analysis, and also offering best practices and other recommendations possibly regarding the testimony of that testing. And I'm prepared to make that in the form of a motion unless there are any questions or comments or concerns.
I would just add that this is going to be very interesting and significant for the commission, because we haven't actually looked at latents or friction ridge until now. The people we have received, I mean, Ron Smith has already looked at what the Harris County Public Defender's expert, Henry Swafford, has provided. And they are extremely interested in how, the commission will view this, and they've been very responsive. And I think what's interesting for me is you have one of the most well-known latent print laboratories that trains all kinds of examiners. And then you have also a very well-known and respected latent print expert, formerly with the U.S. Army Lab, and Henry Swafford. So these are the best people in the business, really. And so trying to understand whether this is a question of inter-examiner reliability, or whether it's a question of people not looking at the same quality of evidence, or what is going on, is, to me, extremely fascinating. And potentially, the commission will be able to set some expectations, hopefully, that might be adopted in other parts of the country. So,
Yeah, this has potential for significant impact.
mhm.
All right, motion's been made. Is there a second?
Second.
All those in favor say aye. Opposed? Okay, so we need to determine panel members. The recommendation was Dr. Bazzini, Dr. Coble, and Mr. Daniel.
Yes, sir.
Okay, it's pretty significant. Okay, so panel members have been nominated. Do we need a motion on this? Okay, so is there a motion to accept the panel members as described?
So moved.
Second?
Second.
All those in favor say aye.
Aye.
Opposed? Okay. All right, that would be the end of that. Very appreciate your work, Mr. Daniel. Item number 5 is the discussion about the Crime Laboratory Accreditation Program and the things surrounding that.
Sure. So this quarter, the commission considered 6 accreditation-related events. And as you all know, these reported nonconformities, we categorize them as a self-disclosure, a reported licensing event now, or in conjunction with this accreditation memorandum that you have in your meeting materials. Among the issues we documented and evaluated this quarter was one, renewal of accreditation, where 4 nonconformities were cited. And I think 2 of those just raised some red flags for Lynn and I. So we reached out to the laboratory and asked them about those. Issues we had questions about are described in your meeting materials. We think for the most part, they're sufficiently answered based on the laboratory's responses. But if you all have questions about those, please let us know. Did you want to talk about those in more detail?
Just the DNA reference lab is what Lee's referring to, and there were some questions about how they were labeling and storing evidence. Excuse me, we followed up with them, and it seems that some of the nonconformities involved a move of evidence where some boxes that had no evidence in them were sort of left without resolution. And it seems like they also do both. It's not like the labs like, Texas DPS or UNT or something. They also accept people who walk in and want to have a DNA profile taken from a buckle or whatever. So there definitely are non-criminal matters, non-civil matters, non-paternity matters in the mix. So they have assured us that they have remedied the labeling and tracking issues. So I think they've done what A2LA asked them to do. I'm not sure there's much more, but their original explanation was a little bit cloudy for us. I will say on first talks, the CAP requirements that were cited as deficiencies, whenever we see a lot of CAP deficiencies, it always raises in my mind a pretty fundamental question about the difference in thoroughness, robustness of the CAP accreditation versus, ANAV or A2LA. And they're there. I mean, they were created for a different purpose. It's the College of American Pathologists. So, but yeah, I think there probably needs to be a consideration of, we inherited CAP as an accrediting body when Texas DPS was doing accreditation for the state. And the more I see these deficiency reports and how quickly they're resolved and how basic the issues are, the more I wonder about whether this is an accrediting body that should be recognized for forensic casework in criminal matters where it's life or liberty.
I think this issue might come up in the expert talks agenda item. So maybe we can address that there. I have a question for staff. How many of the labs are solely accredited by CAP? If we were to make a change, and we'll discuss that later, how many labs would be impacted?
So we reviewed that once, and I think it's less than 10. So it's a very small.
The issue with those labs, though, is that they are not typically taking forensic casework as casework from law enforcement or, prosecutors' offices. They are doing the work for other purposes, which, if you look at 38.35 of the code, probably does not require accreditation because there are those exceptions. And then they end up in court for criminal prosecution. So a judge would evaluate whether it should come in under traditional evidentiary rules, which is different than the commission saying that this accrediting body is sufficient for purposes of, conducting examinations of physical evidence for the purpose of connecting them to a criminal action. That's different. So I know the reason DPS originally accepted CAP and SAMHSA was because they got requests from labs that were like, well, sometimes our cases end up there and it'd be easier for us if CAP were on the list or if SAMHSA were on the list. But when Pat Johnson was on the commission, if you recall, he said it was more for that, facilitating a smoother transition when they adopted accreditation. They never did a real sort of policy assessment of whether CAP or SAMHSA were appropriate, especially when one puts them side by side with ANAB or A2LA. That's a long-winded answer, Dr. Kerrigan, but most of them are not doing forensic casework as what they set out to do with the sample. It's that the sample results then end up in a criminal case.
That's what I suspected, but thanks for confirming it.
I don't have anything else on
I
a.
don't think there's anything else on
Yeah.
this. Just number 5, we can ignore because the quality manager has resumed her duties. I got an email about that yesterday, but I think that's it on the accreditation unless anybody else has questions for us.
Okay. Is that it for number 5? Okay. Number 6.
On 6, our licensing committee met yesterday at 10:30 for its quarterly meeting, as you all know. Just to give you an update on the status of our licensing program and the licensees, we currently have 1,352 licensed forensic analysts that are licensed to practice in Texas. This year is going to be a big renewal year for our licensing staff of one person, really. 173 folks are going to be renewing in October, and then the bulk of them, the rest of those 400 more in November and December this year. So we'll be very busy with that, and between that and piloting a new test as well. If you all look at the licensing disclosure memorandum, we had one licensing issue disclosed by the Austin Police Department where the quality manager discovered that one analyst should have been licensed when they weren't initially, and they gave us a lengthy explanation as to how that happened management wise and some of the changes that they've made. I think the issue for Lynn and I was whether the work of this analyst involved any cases that were subject to licensure, because she primarily, when she started, she was doing just the NIBIN entries. But later on, she was promoted to a firearms examiner after July of 2021, and she still wasn't licensed until February of the next year. So the laboratory looked at all of her cases. I think there were like 1,300 during that period. And the bulk of those were NIBIN entries, and there I think were 6 cases where she had actually performed function evaluations or test fires. And so they're looking at those. 4 of those cases that involved test firing or function evaluation were all reported to those 4 that were reported to the DA's office, so that the DA is aware of the situation. And I think 2 of those cases during the time period involved only NIBIN entry only. So I think they've handled it sufficiently. I'm not sure that we need to take any other action in this, but it just highlights some of the confusion around licensing. And we looked at our notification letter. This person had taken the licensing exam. We give them a notification letter afterwards that some folks have been confused about whether or not that means you're licensed or not. But we do clearly have a statement in there that says, this is not your license. You have to go in, apply, fulfill the rest of your obligations. I think this person was just in the process of getting her transcripts and just let it fall by the wayside. So I'm not sure there's anything else we need to do.
Except bold cap the statement.
We're gonna put it in bold.
It's only happened twice out of the 1,300 people, right? We had one other example where they thought passage of the exam automatically granted the license. So I think most people understand. And, we did have a conversation with the quality division at APD about the need to really disclose this to the DA's office, whether it's NIBIN test fires or actual comparisons, because the legal system needs to sort out what happens, if anything, when you have an unlicensed person who should have been licensed, even for the NIBIN test fires, practicing. So, maybe it doesn't matter, maybe it does, but that's really for the lawyers and the courts to assess. So they've done that.
I think the other thing here, the last thing is the General Forensic Analyst Licensing Exam. The second version of that, we've been working really hard, staff and our licensing committee, on drafting questions for those. And we finalized questions in 6 of the 7 domains with our psychometricians. So we're really very close to uploading those and having the test ready to be piloted. The other piece of this are the study materials that accompany the tests that we've completely revised. We have those ready to push out as well, so we hope to get those out next week. Our plan for piloting the exam is primarily we've been focused on those disciplines that are now going to be able to be voluntarily licensed. So we're going to have a pilot session at the TDII conference that's in San Antonio this year on June 8th. So we've distributed a flyer about that. And we have a Google sign up sheet and information about how to access the study materials as well. And next, I think we're going to focus on the forensic anthropologists and document examiners and document examination analysts to participate in the pilot as well. Because I think the more participation we can garner in the pilot, the better data we can have to evaluate whether we have a good measure of what we're trying to convey. So that's the progress on that. We made a lot of progress in that area since our last meeting. I think that's it on licensing. Does anyone have any questions about the test?
All right. Let's move on to item number 7. It's the update on Expertox complaint.
So we had left it with Dr. Tim Rohrig's report about the work that was performed in the context of the complaint we received from the district attorney's office in Philadelphia. I'm sure you all recall that report was quite scathing in its assessment of the work that was done. So we contacted CAP, which is the accrediting body, and they were supposed to have it to us within a short amount of time. I think they'd said 60 days originally. And
Excuse me, I thought it was 4 months.
Oh, 4 months, sorry. Yeah, 4 months, but then that passed. So we asked them, well, can we get an update? And the update was, we're not done yet. And then just yesterday, late afternoon, we got another email, which basically says we're still working on it and we'll let you know. It says we are getting closer, but our investigation is ongoing. So my hope is that we have something from them before the next meeting. But again, when one considers the seriousness of the cases that we're talking about, you know, drug facilitated sexual assault, among other things, the pace of response feels quite slow. And, you know, we get little one-liners, no real understanding of the scope of what they're doing. Or part of my question is whether it's because, you know, the accrediting bodies have confidentiality agreements with the labs sometimes. So maybe they feel like they can't say anything until they're done. I don't know, but we are not getting very much information from CAP at all.
So I see this as a real risk for the commission. We don't have our own accreditation program. Obviously, we recognize other established accreditation programs. And when we continue to recognize an accrediting body that is non-responsive, that cannot complete an investigation within a reasonable time frame, 4 months with really no information, and we're continuing to recognize a lab as being accredited, that's problematic, I think. I'm concerned that that actually presents risk to this commission, continuing to recognize them as an accrediting body when they are not responsive, as other accrediting bodies are.
But then this may force the issue of making a decision on it by their lack of response.
I think what we could do is send a letter saying that we're considering removing them and that it will be on the agenda for the next meeting, and explain why. And then if they want to respond or attend, they can do that and let us know what compelling reason we should have for keeping them on the list, essentially. They may not feel strongly about it. I don't know. I mean,
Yeah,
they may not,
right.
because that's not really
Good thing.
their primary work is not necessarily affiliated with criminal matters.
And that may be part of why there's a slow response, is the people evaluating are really not experienced in this.
I don't know if they've outsourced components of the review or if they're doing it internally or what, but I do think the lack of response or the sort of stilted, barely any information responses, they're concerning.
So if the recommendation is that we postpone this issue for the next quarterly meeting, we're essentially giving them 3 more months. Would it be a good idea to communicate with the labs that are accredited by CAP to let them know that we are going to be considering that? Because at least we're giving those labs advance notice that this could impact them. It sounds as if, for the reasons you described before, it's not really, that they may not even need to be accredited anyway. So we certainly don't want to pull the rug out from a lab that is solely accredited by CAP, but perhaps we can notice those labs after this meeting.
We can include that.
So that they know this issue will be coming up.
Yes.
Do we need a motion on that?
Yes.
Yeah. So you make the motion?
I'll make the motion to provide notification for the labs that are currently accredited by CAP and the Texas Forensic Science Commission that we will take up the issue at the next meeting.
Is there a second? All those in favor say aye.
Aye.
Opposed? Okay. Next item is the update regarding the Fort Worth Police Department Crime Laboratory.
Yes, so we approved a draft of a report at the last meeting that included professional misconduct finding against the analyst who lied about her DNA coursework when submitting her City of Fort Worth job application. And in that report, we also had a negligence finding against laboratory management. The City of Fort Worth contacted us to appeal the finding as to laboratory management under a variety of rationales, but one of them was that the commission's governance over the standard of practice in forensic science should be limited to forensic casework and not to hiring and firing decisions. And they asked that we remove the part of the report that talks about negligence as to management, but they do not object to the finding as to the analyst. They also notified us that they're conducting their own investigation, that the lab director is on leave while that is ongoing. The former director of the DNA section or manager of the DNA section is now the acting crime lab manager in addition to her TL or, technical leader responsibility. So there's a lot going on in the lab right now in terms of shifting decision making authority and priorities. And they also have the PT issue with ANAB. So we have included in your materials a revised report that does take out the negligence assessment as to management per the City of Fort Worth's request. We talked to the Attorney General's office about it. We've been assigned an attorney, Vina Mohan. Some of you, well, I feel like Dr. Kerrigan may be the only one who remembers her. She actually was the commission's general counsel before I was hired. So she's known the commission's work for a long time. And in discussions with her, we talked about what it would be like to go through a whole appeal over that one finding through the State Office of Administrative Hearings and the amount of resources that one would need to dedicate to that, which is substantial. I think in having reviewed this, the city did not ask that we take out any of the factual observations that we made. They were fine leaving all of that in, so that the substance of our observations are in there. And so we have left that. We also gave notice to the analyst that we would be considering a licensing action based on the professional misconduct finding at this meeting. And we're proposing revocation for a 2-year period. The AG's office was very clear that they believe that anytime we take action against a license, there should be a clear time frame, that indefinite revocation is not favored in any occupational license schemes. So that's why we have that time frame. And the city has agreed to withdraw its appeal if the version of the report in its current form is acceptable to the commission. Did I leave anything off, Robert? Or that's everything?
I have a question.
Mhm.
If someone, for example, had the 2-year revocation of a license and then sought to become licensed again, if one was to look up that analyst, would it have the previous revocation listed? Okay.
Yes, the whole history is
Yeah.
there.
Okay.
And one of the good things about the way our program currently works is that a laboratory, the threshold requirement for the disciplines where one must be licensed is that the person has to be working for a laboratory accredited in Texas. So the analyst would have had to have secured employment as a DNA analyst somewhere before she begins the application process, which is sort of a built-in check in a way.
Okay. All right. Okay, go ahead.
Lynn, you said the city of Fort Worth was entertaining appealing our report from January on the basis of our exercise some authority over their hiring practices, their interview. But the truth is, she actually went to work after she was hired, correct? She was doing testing in the lab, right?
She had not yet begun testing. She was still in training. That's part of their argument, is that because she was hired, but still in training, and she had not actually touched any criminal matters, it's that piece of it is more of an HR type issue than if she had started casework.
Okay, thanks.
So I guess I'm trying to figure out, they're worried that if we take out the piece that involves the management in this thing, and we have the observations, that's what they're asking. Still say that all the stuff that we saw was concerning to us, but the actual malpractice, the finding that we make, take that out.
Not the misconduct as to the DNA analyst, but the negligence finding itself as to management. They don't mind the observations.
That it
It's
was
that it was professionally negligent for the lab manager to have allowed this person to come and work in the laboratory. That's the thing they object to.
I guess it's just kind of weird to me why they are worried about that part. And
my guess is that the argument is, their argument would be is that that the commission doesn't have the authority to deal with HR issues.
And I guess we're not dealing with the HR issue.
Yeah.
We're saying for the commissions, for purposes of the commission, we believe that this was negligent. We're not governing what Fort Worth, the city of Fort Worth or Fort Worth PD Crime Lab does in any way, shape, or form. So they're looking at this right here and they're saying, well, they can't hire or this person because of that. But we're not trying to run the lab. We're just calling it as we see it. It's a little bit bothersome to me.
I think they think that it's unclear that we are authorized to establish a standard of practice for something like an analyst submitting something on the electronic application and then coming in and saying the information that I provided was not accurate. And what happens from there, I think they very much believe is within the purview of HR, the city's investigative authority, and that if she had gone on to do forensic casework, perhaps that would be different. But I mean, even from the perspective of the DA's office, the primary thing they were worried about is, has she touched any cases? And so that's their perspective. I don't know if they have other litigation that they're concerned about. I don't know, but this was the thing they asked for. And to me, the idea of the substance of the commission's concerns are still in the report. And so in my mind, you know, having a protracted SOA proceeding with all that comes along with that, when one considers how small our staff is, that feels.
I understand that. I guess to me that the concerning part of being on the panel had less to do with the analyst and more to do with the management. That was the more concern from my perspective of what we did, what happened from her perspective, and then what was allowed to happen afterwards was the most concerning part. And so I understand it's still in the report. It's just is a little bit, it's concerning to me that we take out a finding where it was.
The message that I'm getting, one second, Bruce, I'll turn it over to you just a second, is that they appreciate your point and that they are doing their own investigation. That was sort of the message that we got back.
Gotcha. Okay.
Lynn,
Yes, sir.
this is a self-disclosure to the commission, right?
A series of self-disclosures, yes.
Why would you self-disclose if then you don't want to accept our response?
Well, they're required by law to self-disclose.
Okay.
They have to. The Code of Criminal Procedure requires it.
Therefore, I think what we recommend should be granted, should be, you can disagree, but at least it's our job.
So
It's a commission task.
Right. The way that the process works, though, is if we issue a report that contains adverse findings against any party, they have the opportunity and the ability to appeal. And that's what they were notifying us of, is that they will appeal it all the way to the SOA, which is where it would be adjudicated.
Yes, absolutely.
Yeah. So that's why.
But I think.
Mhm. Yeah. No, I understand. It's, I understand.
So
I think,
Lynn, along those lines, you had mentioned potential other litigation. And I could foresee litigation in cases going forward based on what we've discussed today. What would be the position of the commission if asked what our finding was regarding management? Because you could see that happening in some sort of cases where the defense or even prosecution may want to know that. What do we say now that we had this finding, but we were asked to remove it, even though our panel found this to be the conclusion?
So the final disclosure that will go out will be the report that's adopted with the revisions.
So I think I have a related question, and it might have been the question that I heard Bruce ask, and that is, when we have adverse findings related to management in these investigations, it's typically following a root cause analysis where potentially the root cause hasn't been identified, but other causes. It just hasn't gone far enough. But adverse findings related to management are not uncommon. And so if we eliminate the negligence finding in this case, what do you think the impact will be for us moving forward? Because I'm concerned that that's tying our hands, because very often the issue is with management. And I don't see that necessarily as an HR issue. So I'm concerned that this decision will set a precedent for many other self-disclosures and complaints.
And let me add to that, that this is not the first time that we've dealt with Fort Worth PD management with this commission. And so that was kind of my issue, is that he has come through at least twice that I know of. So I was just going to add that part right there.
So I think that we are free to make whatever critical observations we choose to make. And we've done that many times. This is the first time, though, that we have made a negligence finding against management for something other than a casework related type of situation where there was an actual criminal matter and somebody dropped the ball or did not do their due diligence or vet things properly or whatever it might be. So we have never issued a finding of negligence against management. Well, I take that back. We actually did issue a negligence finding against HPD pre-HFSC involving their quality division, but that was in blood alcohol casework with switch samples and evidentiary reports that went out and had to be amended. That's a little bit different than this, where you have someone who's still in training and hasn't touched anything. So I don't know if that would ultimately be the distinction, the distinguishing line, but in my mind, it definitely is different. I think Dr. Kerrigan, I don't remember if you were on the panel for that, but it was a finding against, it must have been HFSC already in the context of a very significantly litigated matter involving the analyst whose name escapes me, the blood alcohol.
Well, I
Anyway.
remember the case.
Yeah, you
It
remember
was
the
it was
case,
The blood
yeah.
that was actually a breath sample that was muddled up. I think you've pointed out the important distinction here for me. So it's a resolved issue. The fact that this does not pertain to a case, an item of evidence, that's an important distinction.
And in that matter, the labeling of the blood was problematic when the officers turned it in, but everything that happened after that led to a report being issued with incorrect blood alcohol, everything after that was a complete lack of willingness to accept responsibility for the tech review portion, for the management role, for any of it. It was all sort of thrown at the feet of the one analyst who made a simple error.
Right.
I
you
remember
that.
yeah,
And
so that's a little bit,
retaliation against the analyst.
and there was
as well.
retaliation.
Yeah.
So,
But I think in this case, since it doesn't pertain to an evidentiary test, a case, I think you've made an important point there.
Dr. Rock, can I make a comment? I'm trying to think back. I've been doing this for over 5 years and overseeing these complaints disclosures, and I frequently compliment our staff for how thorough they are and the resources and information they bring to us as we make decisions. And I really cannot recall a particular disclosure that ever had more work and discovery associated with it. Robert did a tremendous job. And we were here in January, and I recall this item consuming over an hour with a number of questions and responses made to it. And then we voted to make a finding that the lab had engaged in professional negligence. And then we find out after the fact they want to appeal that. So let them appeal that. We don't need to run hide from an appeal. We made findings based on facts, based on a careful review of what occurred. And if you look at the analysis that a laboratory could never be found to be negligent in a hiring process, they could hire people that are incompetent, people that lie, people that are convicted, And we're here as a commission to say that's not, don't have a jurisdiction over that. Let the appeal go forward, and maybe let that be decided if that's truly an issue in controversy. But I just can't find it appropriate to withdraw a finding of misconduct by management.
Well, it's not misconduct. That's not being.
I'm sorry, negligence. I'm sorry, negligence. I'm sorry. Simply because they now want to appeal something. That's what the appellate process is for. It's not going to be that time consuming on our staff, and that's why we have the AG's office to represent us. So that's my comment. Thank you, sir.
Okay. Do we have any further discussion? All right. So is there a motion to accept the revisions regarding the Fort Worth PD lab, maintaining the misconduct, but removing the negligence?
As to management.
As to management. Is there a motion?
Can I ask for general counsel recommendation? I think I understood what I was hearing Lynn say, but Lynn, do you have a recommendation for us regarding this?
Yeah, I feel that it is going to be very time consuming. There will be extensive discovery, depositions, all kinds of things that we have a lot on our plate. A lot of it's important work. I think there aren't any other labs in this state that would do what was done here. I think that's clear to me in conversations with every other lab director. They are baffled by the notion that someone would find out that an analyst lied on a job application and then hire them anyway. So if you look at the sort of the big picture of what it is that, I mean, I understand the idea of not wanting to relent on something that you find to be a righteous finding. I understand and appreciate that. Also, looking at the number of attorneys we have, the amount of discovery that would be involved, which is extensive. And, you know, at the end of the day, the lab manager is not, he's on admin leave. The city is working through personnel issues. She didn't touch any casework. And when I think about all of the major investigations that we have right now, and weighing the fact that probably at the SOA, we're going to be asked to settle anyway, because they will want the parties to work through it and come up with some agreement. That process, from what I understand, the SOA is not it's very time consuming and bureaucratic. I mean, ultimately, in my mind, you know, just because we've never been asked to negotiate a finding doesn't mean that it won't happen. There may be other examples of that. This is part of the process. They have a right to appeal. And at some point, we will be asked to engage in settlement discussions anyway. And our rules provide that we can settle outside of a formal proceeding. So in my mind, when one considers resource allocation, I think the report says what it needs to say.
I have a question, Lynn. The revision is the taking out the finding of negligence by the Fort Worth management as a whole. Am I correct?
Yes. Well, yes.
Right. As
hiring
to
people. Mhm.
Sorry,
The
say that
two
again.
who were responsible for hiring.
Okay, so I think it was Ward, I think was the head, is that correct? As to him specifically, that is included in this whole deal, correct?
In the request, yes.
In the request.
Well, the finding is to the lab, not.
Right, the finding is to the lab.
Wasn't this to Mr. Ward individually?
But the
He was
management is,
Would the legal counsels, would the person you were talking with, the lady you mentioned before, would that change if it was specific to the lab manager?
no, because they're the primary actor for the laboratory. They just want the negligence piece out. They're
Okay.
fine with the misconduct against the analyst, but they want the negligence finding out.
Lynn, I know you mentioned that the manager is on leave, but the other person involved in this negligence finding is now the acting director. So that doesn't necessarily resolve the problem in the interim.
Well, I guess it depends on how good of a job is done
Right.
with the new structure of the lab. I mean, I think they're pretty stretched thin right now there. I think they're doing the best they can. But it's a challenging time because you have one person who's the lab director, the lab's assistant director, and the TL for DNA. It's a lot that they're going through right now.
I understand that. It's just the point is that you may not have resolved the culture of the lab and its beliefs and practices in its current state.
I'm not sure that any report we would ever issue would resolve the culture of the lab with one, I mean.
Right. But
I think the observations that are in the report are clear on the issues that the commission was unhappy with.
I
And
agree.
they're framed in very strong language in my mind.
I agree with you on that, but it is still not necessarily by dropping the negligence finding resolves the problem.
No, that's true. That's true. What you say is true.
Okay, we're back to the same point that we're at, whether there is a motion to adopt the revisions. And I'm willing to make the motion if there is a second.
I'll second it.
All right, so now we need to take a vote for a decision one way or the other. All those in favor of accepting the revisions, say aye.
Aye.
Those opposed?
Opposed.
No.
2 noes. Okay, motion carries.
Can I just make I don't know if it matters for anything, the statement on the record, being in the hearings, getting a chance to listen to some of the people that were in management, my issues and concerns had nothing to do with that. There was one particular person in my mind that was driving this train that put them in a world of hurt. The other people, I think, did a pretty good job trying to deal with the situation, coming forward in the situation when there was a problem, trying to rectify the situation. So my vote is not about, I believe it's Miss Johnson, what's her name, Mr. Aviles, I think that was his name. It's not about those individuals. It wasn't. I thought they did a pretty decent job in this particular situation. But this was something that I had never seen before, in my view, as a commission member and as a prosecutor, and it had nothing to do with them. So
I think that the city of Fort Worth has some obligations to address this significantly, or we will be back and continue to deal with these things. All right. Item number 9, update regarding the complaint from the Innocence Project.
So there are 2 things that we're expecting on firearms. One is that NIST does these scientific foundational reviews. And they are going to release one within the next couple months. First, it was May, and then they said probably closer to June or July on firearms, where they're reviewing the I think it's about 3 dozen key papers that have been done describing different studies where some form of reliability or accuracy has been assessed, and the studies are not all the same. They don't take the same approach. They don't all have the same number of samples, but these are the materials that the community points to as supporting the foundational validity of the discipline. So it does not make sense for our commission to duplicate efforts, and it doesn't mean that we're going to accept what NIST says whole cloth. There may be things that don't make sense or that we disagree with, but the evaluation of the literature will be very helpful. And they've been working on it for a couple of years. The other thing is that David Kay, who a lot of you know, he volunteered his law students from Yale who are in a clinic to give us a paper analyzing a recent publication by CSAFE that talks about the use of inconclusives under the AFD guidelines about how the AFD theory of examination or theory of identification, sorry. So I'm expecting those two things in, and they will be very helpful in our drafting of the report. So I anticipate that we will have a draft for our July meeting is my hope. But it didn't really make sense to not wait for the NIST publication.
Okay. Item number 10, regarding the complaint, sexual assault nurse examination.
I always have a little, should I proceed from here or do you like me to stand?
Wherever you're comfortable.
Okay. This is just an overview of the report that you have copies of. This is a complaint by the defendant, Damon Lewis, saying that observations of the same nurse in his trial is inconsistent with published literature and guidelines. This is not an accredited discipline by administrative rules, so our report is limited to observations about the reliability of the analysis and identifying best practices in the field. This gentleman was convicted in 2002, several counts of sexual assault of a child involved his 9-year-old daughter in digital vaginal penetration. And this concerns the examination of the child's hymens. And the published guidelines in the area started in 1992 by a person, Dr. Joyce Adams, and a whole group of other practitioners that put together a classification system to deal with these findings. And this literature evolved over time as they gained more experience. So additional publications would come out, such as 94, 96, 2001, et cetera. There's a 2018 version of this same guidance that's currently relied on by practitioners. So a couple of observations related to the testimony in his case. The same nurse testified that the child's hymen develops wear and tear that indicates if somebody may be sexually active. Later in 2004, there's a study that's published guidance that says there's no evidence to support such a claim that you can determine whether someone is sexually active based on the visual appearance of the hymen. The main observation here is the same nurse testified at the trial that she observed little pie-shaped wedges that indicated there was a well-healed tear on the hymen. This indicated something had gone past the hymen, was big enough to cause trauma to it. And this is her testimony in 2002. There was a study put out in 2001 by this group that indicated that a notch or a cleft that doesn't go through more than 50% of the width of the hymenal ring is a non-specific finding. The current literature is that the only non-acute hymenal finding considered clear evidence of past injury has to be a complete transection of the hymen with no tissue discernible at that location. So as we looked at this, the observations were that it's an abnormal exam and it should be reviewed by a second expert. It doesn't appear this one was. The testimony of the same had a lot of ambiguous language, difference between a tear and a notch, and it went into scars and clefts and a lot of terminology that's not clearly defined. Current guidance is you call it a notch or a cleft, and those are interchangeable terms, and it refers to an area of the hymen where the tissue is indented somehow. During the testimony, the same testified that the physical examination of the child backs up the child's story And our observation is that they are trying to use objective language when asked to provide an opinion. The SANE expressed to the commission that what she meant to convey was that her findings were consistent with the patient history. And most importantly, the documentation did not include any indication of the depth of the notch observed by the SANE. So under current guidelines, it's impossible to assess the accuracy of her interpretation because it wasn't documented at the time. So the summary of the finding is the testimony by this nurse at trial was inconsistent with the 2001 child abuse guidelines that were in place at the time of the trial in 2002, as well as current guidelines in 2018. So this report contains recommendations intended to assist the nursing community. Forensic nursing was recently added as a subcommittee to the OSAC. And several recommendations. One is that they study the terminology and endeavor to create a glossary of preferred terms that everybody can use that have clear definitions. The case reviewed by a second expert, it should be a core requirement of an OSAC standard. Our documentation recommendation is that it's critical that these findings be documented in detail. As noted, there's impossible to tell from the notes taken at the time of this exam where it's impossible to evaluate against current standards. Commission has observed a gap between published literature and the understanding by practitioners in the field. So effort should be made directing the dissemination of evidence-based knowledge through continuing education. Data-driven interpretation. This guidance is historically based on the consensus of practitioners, and it's our observation that establishing standards based on empirical data is more likely to lead to reliable and accurate outcomes. So the OSHAC should focus on the need to collect and evaluate data as the foundation for future guidance. And then on the human factors field, you have a patient history that's a critical and component of this work. So OSAC should work with a human factors expert to develop training and guidelines focusing on confirmation and other cognitive bias. That's the substance of the report.
Dr. Downing was instrumental, as you might imagine, in making sure that Robert and I got it right, because there's a lot of guidance, and perhaps one of the reasons why OSAC will be helpful is because it's not clear that the guidance was disseminated in a consistent or universal type way, which we've seen in other areas as well. And since Dr. Downing is on the OSAC subcommittee, I think she can provide this report. I hope they will be receptive. I didn't know if you had any comments, Dr. Downing, to add?
No, just first of all, thank you for the care that you and Robert took in making sure that we got this the way we wanted the wording to be. So I really appreciate that. And I will definitely take it to the OSAC subcommittee and they will be receptive. I'm sure they'll be very grateful. Thank you.
All right. Is there a motion to adopt the final report?
Dr. Kerrigan had something.
Oh,
Can I
sorry.
just make one comment? And it's really just a minor clarification. Before we vote to approve the report, can we make sure that in the final report, we don't refer to OSAC standards, because OSAC doesn't actually create standards. We put them on the OSAC registry, but they go through a standards developing organization. I saw it in the PowerPoint and it may not be in the final report, but can we just make that tiny
OSAC
change?
registry standards, yes.
Yeah, so we can just refer to the standard.
Yeah. I should have caught that. I'm sorry.
It's very minor. It's a great report. Great work for the subcommittee to sink their teeth into.
Thank you.
All right. Any further discussion? All right. Is there a motion to accept the final report?
So moved.
Second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. Next is item
Aye.
number 11, which is the Discussion of the final report for the complaint 21.54, James Smiley.
Okay, so this is a report discussing one of our all-time favorite subjects, which is the interpretation of complex DNA mixture evidence. So this was a complaint filed by Mr. James Smiley, and he was charged with sexual assault. And in January of 2021, pled guilty to 2 counts. There was evidence submitted for forensic analysis, including the survivor's tank top and undergarments. The reason that the commission accepted the complaint, you'll probably recall, was because originally when the manual interpretation of a DNA mixture extracted from cuttings from the underwear, when that was originally performed, the laboratory, which was Signature Science, pursuant to an outsourcing contract, when they originally analyzed it, they came up with an uninterpretable result. They said the mixture was too complex and they weren't going to interpret it. Then the assistant district attorney who was assigned to the matter eventually asked for star mix reinterpretation. And in that reinterpretation, the defendant was excluded. Mr. Smiley was excluded. So that's why we accepted it to take a look at the original interpretation and to try to figure out whether the data that were originally reviewed had enough information to allow the analysts to exclude, even with the manual interpretation or not. So just to go through the reporting, in April of 2019, SIGSI issued a report identifying semen on the cutting. There was a presumptive test for blood that was positive, and they designated the epithelial cell fraction or the non-sperm cells, and then the sperm cell fraction. So they extracted it using 2 steps, which is common. And what they originally said was that sperm cell fraction from the cutting had a mixture of at least 4 individuals with at least 1 male. And they said that no further conclusions could be made because it was too complex under their SOP. And then for the non-sperm cell fraction, they came up with a mixture of at least 3 individuals and also said that no further conclusions could be made. They did have this very important language, which I think a lot of labs adopted in their transition to ProbGen, saying that these results may benefit from probabilistic genotyping analysis. And if you want, we'll run it once we have our system up and validated. So as I mentioned, that happened. The ADA made that request. And the results from the star mix reinterpretation said that Mr. Smiley was excluded from the sperm cell fraction as well as from the non-sperm cell fraction. So just in case anyone needs reminding, which I know you probably don't, the technology for DNA analysis has become more and more sensitive over time. Smaller and smaller amounts of DNA have become able to be detected, and that results in more complex data being generated than perhaps was done in the early days of DNA. And the more data that are generated, the more possibilities and the harder it is to analyze how many contributors are there and who might be or might not be a contributor. However, having said all of that, Doctors Badoli and Coble both pointed to literature through the years that indicates sort of a concept, which is that laboratories that essentially walk away from a very complex mixture as too complicated to make an affirmative association still should be evaluating that data for potential exclusionary information. So one might not feel comfortable proceeding with an association, but there could still be sufficient data there for one to rest comfortably in the conclusion that this person of interest could not be a contributor to that complex mixture. So in the report, we talk about the case of Lydell Grant, which we discussed at this meeting in January of 2020. And I went back and looked at it the other day, and Peter has the same amount of hair now that he did at that meeting. You'll be happy to know. But Peter was talking about this case because it was an HPD case. It predated his role as the scientific head of HFSC. It was an HPD case, but it's a really fascinating and tragic case, although now Mr. Grant has been declared actually innocent by the Court of Criminal Appeals. But if you remember, he was convicted of a murder of a victim outside a nightclub in Houston. And the mixture that was analyzed was from fingernail clippings. At the time of the original manual interpretation, the analyst testified that she couldn't reach any conclusions, but then when she was on the stand, she went on to agree with the state's wording of the inconclusive as Grant not being able to be excluded as a possible contributor. So that is a bit of a different statement. Post-conviction, the Innocence Project of Texas took Mr. Grant's case, hired an expert to review the data. Both Drs. Coble and Bedoli ultimately got that same data, looked at it, and concluded that there were sufficient information originally to have excluded Mr. Grant, but that was not done. Meanwhile, IP had sent this off to Cybergenetics, which is the maker of Truleel software, and their analysis excluded Grant and found an unknown male profile. Through an agreement that Cybergenetics has with the Beaufort County Sheriff's Office lab in South Carolina, they uploaded that unknown male profile to CODIS, got a hit against an offender who had been in the Houston area at the same time and who had a long list of violent offenses as well. So then the Georgia law enforcement agencies and HPD went looking for this alternative suspect, found him outside of Atlanta, and he ultimately confessed to the crime. And in May of 2021, the court granted Lydell Grant actually innocent. So this is a very fascinating and troublesome case. Now, I should be really clear that Mr. Grant had 6 eyewitnesses who said that he was the one who had done the stabbing. So I don't mean to imply that the DNA inconclusive finding was necessarily, we don't know to what extent it contributed to that wrongful conviction. But what we do know is that the lab had data in its possession at that time that leaned toward a clear exclusion from everything that Bruce and Mike looked at, as well as the other experts, and they did not make that exclusion. So we don't know what would have happened if they had, but that is clearly backed by the evidence we have. So what we're seeing is sort of this gap where you talk to Dr. Bedoli, for example, and he'll say, but we've always said that they should be examining the data for possible exclusion. This is in the literature. And then when we talk to the labs, they say, yeah, but that's tricky. It can be difficult to do that. And we're not always sure how to do that. Because we don't want to engage in suspect-driven analysis where we're looking at the knowns and working our way backwards. So it's a little bit more challenging. And so what we see is this gap between what's in the published literature and what's happening or what has happened historically in the labs. And that has really been highlighted by these probabilistic genotyping reinterpretations where one sees the difference from the manual interpretation to ProbGen. Now, I should also say that some of the labs were doing exclusions as well. There's actually quite a bit of variation out there. So I think originally the labs that don't perform the exclusionary step had they were well-intentioned in not wanting to wrongfully include or exclude anyone. But then you have this unintended consequence. Which I think is probably unacceptable to most stakeholders, because without that information about the exclusion, how does one know whether they have the full picture of the information about the case, especially when you have an unknown assailant. And so the position in the report is that if the data support an exclusionary result, the lab has an obligation to get that information to stakeholders. And then we cite a couple of publications, and one of them was Bieber et al., which had we paid for that to be open source so that the information would get out there when we were originally looking at the CPI issues with DNA mixture interpretation. So in this case, the lab SOP certainly allows for an exclusion, but it doesn't instruct the analyst to inspect the profile for exclusionary data after having determined it's otherwise too complex. Our position in this report is that Smiley should have been excluded during the initial manual interpretation based on the number of contributors identified by the analyst and other assumptions that were made about what was a true allele and what were artifacts. And we see that in the case record. So we're basing our review on the record and on the data. One example is at the SE33 locus. If one assumes 4 contributors, Smiley would be unequivocally excluded. And that exclusion is also intuitively supported by the star mix output, which, as we saw, returned an LR less than 1 at 13 of 20 loci, so more than half, plus a 0 LR for SE33. So we looked at, there was obviously no misconduct that was never even on the table. We looked at negligence because we're required to by law, and the analyst followed the lab SOP. The protocol did not direct her to inspect the mixture for exclusionary data, so she didn't. SIGSI is not the only lab that doesn't inspect complex mixtures for exclusionary data, so we thought a finding of negligence is not warranted in this circumstance, but rather a broader discussion about how we should be approaching these cases. So the recommendations are that if the lab is currently performing manual interpretation, which some still are, even if they have brought StarMix online, sometimes a manual interpretation is needed. They should ensure the SOP includes guidance on how to assess the mixture for exclusionary purposes. The analysts need to understand the factors to consider in making that assessment. The labs have a responsibility to ensure the analysts understand the literature and the rationale for the guidance, whether or not they've transitioned to probabilistic genotyping. Labs should be willing to reinterpret previously reported and conclusive results for probative samples where an inspection for exclusion was not originally conducted. And those are the main recommendations. I can tell you, and Dr. Coble or Dr. Bedoli could comment on this, but in conversations with the lab, it appears that there really is a level of discomfort around when one should make these exclusionary calls. And I think it's something that both of our DNA subject matter experts think needs training. So I think we will do a training on this report for all the labs, regardless of whether they're running StarMix or not, or any other probabilistic genotyping software. So did you have anything, Dr.
Yeah,
Coleman?
no, exactly. I mean, I agree that there is a need for training and education in this area, because there are labs that have not yet brought on StarMix that are doing this manually. So there needs to be some more guidance, even though there have been some publications that you referenced in the past. It's still a topic that needs further discussion.
Mm-hmm. Yes. Dr. Bedoli, did you have anything to add?
No, I think you covered it well.
Can I ask a couple of questions?
Mm-hmm.
Obviously, this is not my area of expertise, but it does come up sometimes in sexual assault cases too. So I'm interested in how much subjectivities involved in making those exclusion? Is it just a training issue that once you're trained on it, there's very little subjectivity, or is there some subjectivity involved in the interpretation of that exclusion finding?
I mean, personally, I think when you're interpreting evidence, when you're interpreting DNA mixtures, especially very complex mixtures, when you have 3, 4 or more, then there can be these elements of subjectivity that could come into the process. So that's where I think there's a real need for training and the educational part of how to determine when to say that it's too complex and I can't even make a decision on exclusions. I think in this particular case, as outlined with that locus at SC33, it was fairly clear that if there was an assumption of 4, then the person of interest here would be excluded.
Okay.
And there were other loci too that came into play, not just that one.
So sometimes it's pretty clear once you're trained to look for it, and other times there is some subjectivity.
Right.
Is there also the possibility of, if a lab that does not use Star Mix or have a system of using a software like that, that they would be recommended to send it to another lab that does, or can you not recommend that? I mean, it seems like there's going to be a disparity between labs that do and do not have that capability.
So I think they should be able to get to the exclusion doing the manual interpretation if they're really looking at the totality of the profile and what's the most likely explanation. But most of our labs, even if they haven't brought it up yet, they're in the process of getting there. So, I don't know, for example, for the labs that aren't running ProbGen, if they would send I don't know if they would actually forward that along to a lab that is right now, because it's their case. I'm not sure that would happen. I think they're more likely to just try to bring it online as soon as they can. But what's interesting,
Lynn, the other factor is that most labs, of course, in the US use Star Mix, and Star Mix has to be validated within your system. So the data you generate currently has to be assessed on that platform. So you send it to another lab and it's assessed on their own platform. That doesn't meet the requirements of today's usage. Now that might change in the future, but at this point, that's a limitation.
Yeah, so they couldn't, like if one lab doesn't have ProbGen and they send it over to DPS and DPS comes back with something and then they report it out, like that can't work under accreditation. They have to have validated it themselves. And then
currently,
I'm sorry.
I'm not convinced that that's the right approach, but currently that is the recommended way to do it by the manufacturers and those who use it. So unless that changes, it would be difficult to generate in one lab and do it in another Star Mix laboratory.
And that's even when they use the same software, never mind when you're crossing over. I do think though, like for example, in this case, when we talked to the lab, the issue was brought up, well, maybe it was 5 contributors. But the problem with that argument is they proceeded to run this through Star Mix, which is only validated in their lab for 4 contributors, not for more. And so one would say, well, if you can't run it through because you think it's more, then you violated your own SOP. And then they were questioning some elements of the Star Mix output result. And the answer was, well, then I guess you shouldn't have reported it because it wouldn't have been intuitively supported under that theory. So part of the issue is like getting people out of this mindset that we're going to defend our results no matter what, and getting more into the mindset of, look, we have this great new tool. It's not perfect, but we've got it. What can this teach us about the way we looked at profiles before? That's a little bit, I think, where I think, if I'm not misquoting our subject matter experts, that's where they would like to see labs headed. And by and large, that's what we see. And whenever we interact, I mean, people get it. There've been quite a few of these cases where, you know, the Lydell Grants, the Fred Lees, now the James Smiley, where we're seeing this phenomenon. And I think our labs are super receptive to having this conversation. That's the perception I absolutely have, having called a whole bunch of them in the last 48 hours to make sure that we weren't off target with these recommendations. But it is a conversation that needs to happen with actual data samples that people can talk through and debate and all of that.
There's an absolute need for a post interpretation of the evidence after it's gone through the software, not to just simply treat it as a black box. It gives you an answer, you're done. You still need to go back and interpret. And I think part of that lack or part of that gap is that before Star Mix, the way we were interpreting mixtures was not always consistent between labs and even between analysts within a lab. So there needs to be some additional training to help get everyone over that gap. And then we're now able to interpret after using the software as well.
I'd like to add that the training probably still needs to be done on Star Mix itself as the primary tool, because we're seeing inconsistencies in the interpretation and assessments of the data output from Star Mix. As an example, and we saw it in the Fred Lee case as well, that individuals saying, well, that genotype had some weight, therefore it's meaningful. And in this case, I can't exclude anybody if that genotype exists in any of the genotypes that are weighted in the output. And that's not an intuitive way of looking at the data. So there are some differences even with a good tool that should be bringing people together that needs to be addressed.
All right, there any further discussion? All right, if not, do I have a motion to adopt the final report?
So moved.
Second? All those in favor say aye.
Aye.
Opposed? Okay. Report's adopted. Item number 12 is the update on the forensic biology DNA mixture training in Bexar County.
So we're supposed to be doing this collaborative project with the Bexar County DA's office on training in forensic biology from the point the evidence comes in all the way through. Judge Hervey really wants us to include 11073 writs in there. I think the DA's office wants to talk about chapter 64. So we're talking about all the way through to its ultimate possible end. And it's right now a little bit stuck because a lot of the large venues that we would have used in San Antonio in years past, like St. Mary's has this massive auditorium that's really beautiful, but they don't want people sitting close together, and then we can only have so many people. And then they want some of the students to be allowed to participate. And then when we look at it, we think, well, how many lawyers are we and judges are we really going to be able to fit? So we're having some challenges there. And so what the DA's office did, because they're sponsoring it for everybody, defense, prosecution, and judges from the counties in the region, which goes all the way down to the border, basically. So now they've put a survey out to try to assess whether folks would be amenable to just shifting it all onto Zoom or whether they want to do a hybrid, which is more complex. Actually, the hybrid is the most complicated of all the technology things. Like if you do it all on one or on the other, but to be doing both is hard. But they do it all the time for university classes. So we're trying to work through the ultimate venue, and that's where we currently stand. And I think, did you have anything else to add? No, okay. Judge Hervey's not here, and she wishes she could be, but she's actually in San Antonio today. But we're going to keep working on it. And she has just a lot of great ideas lately about introducing forensic science components into law school curriculum, all kinds of things. So I think she's excited about a lot of these initiatives, which is helpful when you're trying to get the planning done. And the Court of Criminal Appeals has all that grant money too for education. So that's it.
All right. Item number 13 is an update from Dr. Stout. All right. Well, you made your 5 minutes. No, it's lost. You waived that. All right. Any proposed agenda items for the next quarterly, other than carryover for some of the things we already have?
And the issue about the cap.
Yeah, right. Okay. All right. And our next meeting is going to be July
22nd.
Okay. All right. Is there any public comment? Do we have anybody? All right. Do I have a motion to adjourn?
Second.
All those in favor say aye.
Aye.
Opposed? Okay. Meeting's adjourned.
Good job.
Has to be,
Well done.
has to be a record. Dr. Janelle.
He's a Republican. He's pretty efficient.